Good evening, all, and welcome to this webinar presentation of the Sisters-in-Law series. My name is Alan Frosch. I am the co-owner and chief community officer at Tattered Cover Bookstore here in Denver, Colorado. It's a pleasure to welcome you to this presentation. We'll get started in just 1 minute as folks populate, but we are very glad you're here. Thank you very much. Excellent. Again, thank you so much for being here tonight. We're very glad to see you. And this is our fifth and final presentation in the Sisters-in-Law webinar series, presented by Tattered Cover and Theodore Orr. We are very pleased to have you all here with this excellent panel on the topic of legal reform. Before we jump into the panel, I want to give a couple quick Zoom reminders and then introduce our partner from Theodore Orr. First, this presentation will be best viewed in gallery view, as there'll be a pretty active conversation amongst the different panelists. To submit questions, please use either the chat function or the Q&A function at the bottom of your Zoom screen. We're going to divide the presentation into two parts. The first will handle the federal judiciary, and we'll ask for questions on that topic midway through, and we'll pause for that question and answer, and then continue on the rest of the presentation. Please feel free to use the chat to ask questions of me or the other panelists. And with that, it is my pleasure to introduce Diane Gilboa, the producing artistic director of Theodore Orr. Diane.
Thank you, Alan. For those of you who don't know, Theodore Orr is a nonprofit theater company that does not have a subscription base. We produce works that you would not ordinarily see anywhere else, and they have some Jewish interest and universal appeal. We have a number of webinar sponsors. I wish to acknowledge them, so just a moment. This is a real community effort. The League of Women Voters, the Boulder Jewish Community Center, Brownstein Hyatt Farber Schreck LLP, Colorado Attorneys for the Arts, Colorado Bar Association, Colorado Women's Bar Association Foundation, Denver Bar Association, Gibson Dunn and Crutcher LLP, and a special shout out to Gregory Kerwin and Jessica Brown, who helped us put together our amazing panelists, the Mizell Arts and Culture Center at the J, the National Council of Jewish Women, Tierney Lawrence LLC, Universal Lending Corporation, and the University of Denver Sturm College of Law. Thank you.
Diane, thank you so much. And again, it's been a pleasure working with you to put this presentation together. As I said, this is the fifth and final installment in our five-part Sisters-in-Law series based on the book Sisters-in-Law, just to make that very clear. And we're very excited to have an all-star panel this evening. It is my pleasure to introduce our moderator, Dr. Sarah Chatfield from the University of Denver, who is an assistant professor of political science at the University of Denver, and her expertise in research focuses on the American political development, women in politics, and political behavior. Sarah, it is a pleasure to welcome you. And again, thank you so much for serving as moderator tonight.
Thank you so much, Alan and Diane, and thanks to all of our audience here for joining us tonight. So we have three distinguished panelists who we'll be hearing from mostly in conversation over the course of the next hour or so. So first we have Justice Rebecca Corliss, who served in Colorado's judiciary for nearly 2 decades, first as a trial court judge and then a justice of the Colorado Supreme Court. And in 2006, she resigned from the Supreme Court to found IALS, the Institute for the Advancement of the American Legal System, an applied research institute dedicated to improving delivery of justice. And we'll hear more about that organization throughout our time tonight. We also have Dahlia Lithwick, who is a senior editor at Slate, and in that capacity has been writing their Supreme Court dispatches and jurisprudence columns since 1999. And she also hosts Amicus, Slate's award-winning podcast about the law and Supreme Court. And she's currently working on a new book, Lady Justice, for Penguin Press. And finally, we have David Yellen, who became CEO of IALS on June 1st. Previously, he served as Dean and Professor of Law at Loyola University, Chicago School of Law. And I want to start this evening's discussion before we jump straight into legal reform efforts and thinking about potential solutions to what's going on in the judicial system. I want to start with this question. So what do each of you see as the most pressing problems with the US legal system today? And maybe we can start with Dahlia and just have everyone take just a couple minutes to highlight what you see as the most important problems, either at the federal or state level.
Well, so first of all, thank you to Sarah. Thanks to everyone who has wrangled this panel in this series. It is a real honor to be with you and to talk about, I could talk about the two justices for 172 years and never grow tired. So this is really a treat for me. I think my sense is that the challenge is of a piece with this larger, just complete lack of faith and confidence in institutions generally. And I think we almost can't cognitively keep up with how fast confidence in, not just the courts, not just the federal courts or the state courts or journalism or the postal system or the franchise is, really cratering. But I think that a lot of the moves that the judiciary is making to try to push back create these unforced errors. So I think that we're in a funny symbiotic meltdown where, as public confidence in the integrity, the independence of the judiciary is decreasing, we're also seeing the judiciary making, at least what I'm looking at, which is the Supreme Court and the federal judiciary, really unnecessary moves to escalate that. And so, my concern is at a moment when I think Americans are just looking desperately for stability and for authority and for the grownups in the room, it's really, really essential for the judiciary to step into that space and behave as independently and neutrally as they possibly can. And that what I worry about is anything right now that is just the most infinitesimal hint of partisanship is not simply, exploded by a partisan culture into partisanship, but also serves to further erode a general trust in an institution that I really believe now more than ever we need to have trust in. So that's my very existentialist first cut at the problem.
Thanks, Dahlia. And Becky, why don't we go to you next?
I agree completely with Dahlia that the most fundamental problem is lack of confidence in the judiciary. But I would couple that with a lack of understanding of the judiciary, a lack of understanding of what courts are actually supposed to do and how they're supposed to do it and what judges are supposed to do within that system. So I think it builds to some extent on what Justice O'Connor, interestingly enough, called out repeatedly over the course of her professional life after she stepped down from the Supreme Court. Most pervasively is a lack of civics education, that people are just not taught how the three branches of government work, and hence they're very susceptible to being sucked into the notion that it's just partisanship, that judges are politicians in black robes. And sometimes that's actually true, but most of the time it's not. And most of the time that misconception comes from a really fundamental misunderstanding about what judges are supposed to do.
Thank you. And David, want to share with us kind of your thoughts on this opening question?
Sure. I'll say three quick topics that I think are the most challenging and important for the legal system, not just the judiciary. The first is to agree with both Dahlia and Becky that the crisis in the perceived legitimacy of the Supreme Court is a uniquely important and difficult problem. And I'm sure we're going to talk about that some more. Second, and this is something we'll talk about a little later, on the state level civil justice system, there's a crisis in the number of people who don't have adequate access to legal services in matters that are, life-changing events for them. That's number two. And number three, on the criminal law side, we remain, despite some changes in recent years, we remain a country that relies more heavily on incarceration than any other advanced country, with the enormous racial disparities, and that whole package of things, I think, is an ongoing, continuing crisis in the legal system.
Thank you. So as I mentioned, we're going to kind of divide our time between talking about the federal judiciary and the legal system in the states, and we're going to start at the federal level. And so I'll invite our audience to share questions throughout as they might occur to you. And we'll have some time sort of midway through for questions about the federal judiciary. And you can do that through the Q&A or the chat. Only the panelists and myself will see the chat, so it won't be broadcast out to the entire Zoom room. But for this section, I am going to ask our panelists to just have some conversation. So please feel free to jump in as you have something to say. But I want to start with this list of recommendations that came out last week. Biden has had this Commission on Court Reform. They just issued recommendations last week. And some of the reforms discussed by this commission range from term limits to changing the size of the court or its jurisdiction. There's been concerns about ethical reforms. And so as an opening question, when it comes to the Supreme Court specifically, first, which reform or reforms do you think are the most important to focus on? And then which, if any, do you think actually have a chance of realistically happening during Biden's presidency?
Ooh, Dahlia, you go first.
Right.
I mean, I think there's a split screen problem that precedes even the recommendations. And that is that we have, I don't think this is a controversial statement, but we have, at least with respect to the Supreme Court, but I would say the federal courts generally, a problem wherein it is without a doubt a political football as a political matter. And it has been treated as a partisan political football, certainly for decades. But I think maybe we could just stipulate that certainly the composition of the court right now reflects a lot of political decisions, including decisions by Democratic appointees about not retiring, to coincide with the political cycles, and then decisions made by the Senate about, both blocking Merrick Garland because it was the last year of the presidential term, and then forcing through Amy Coney Barrett because it was the last year of a presidential term. So I think we have a problem where we want to construct an argument around the proposition that it is completely political and partisan until the second that somebody has their investiture ceremony, at which point it is totally oracular and nonpartisan, and it's balls and strikes all the way down. And I think that part of the problem with the commission, and we should be really clear, it wasn't a report and it wasn't recommendations, it was 200 pages of working documents that still, I think a lot of the two commissioners quit last Friday. Several of the commissioners called out the report last Friday. So who knows exactly what the status of the thing is. But I think that there was a decision to sort of say, we're not going to look at all the partisanship in the political process that constructed the problem. We're going to look at the problem of legitimacy. And I just am not completely confident that the American public is on board with that choice, to sort of say, who knows how we got to this moment where, the Supreme Court has this sort of 6-3 supermajority. Maybe it's just an accident, but let's think about it going forward as a problem of court legitimacy. And I think it seems to me, having looked at the recommendations, that even the ones that had broad bipartisan support going into the report, which would be, I think, the term limits, the 18-year term limits, even that, having been laundered through this process of, oh, we don't want people to lose confidence in the court, even that has been dismissed, I think, largely by the working group. So I think that we have to, I often cite one of my favorite books is by a political scientist, and it's called All Judges Are Completely Political Except for When They're Not. I think that's the split screen we're having right now, that this is a very political process that wants to then tout itself as neutral. And the commission, I think, had a very, very hard time, because if the only project is pursuing that neutral, oracular, hands off the judiciary because it's dangerous to not have a judiciary, and dismissing everything that came before and all the valences around it, I just think that there's a huge problem, because the political story is still there. It's in no way flattened by the commission. And so I think we're just in this split screen world now. I'm not sure that was entirely responsive, but that's my sort of framing.
So I'm going to start with the specific and then move to the general. I think the most promising possibility is term limits. It is consistent with every other Supreme Court in the country, which does have either mandatory retirement or term limits of some sort or another. I sat on a court where we were placed on the bench for a term of 10 years and then up for retention for another 10 years. And there was a mandatory retirement age. It promotes certainty. It promotes an atmosphere of change, because there are new people moving in, which we all acknowledge changes the approach of a court. If a plumb line ultimately swings sort of toward the center, if you place people on either side of it, the plumb line tends to move. And I was on a court where I saw that kind of movement with changing membership on the court. So starting with that specific notion that I think term limits would be a positive development for our United States Supreme Court. I think when the founders put this in place, they had no reason to believe that people were going to live into their 80s or 90s and remain on the court for that period of time. And in some instances, that's been a blessing, and in other instances, it hasn't. So moving to the more sort of esoteric or existential analysis, I think the problem is that we can't quite figure out what we want from the Supreme Court. We don't know if we want them to be kind of figureheads and leaders and Brown versus Board of Education, or if we want them to be very constrained by the cases in front of them and, deciding the law like Holmes would say, the great tapestry of the law, stitching or weaving it together thread by thread by thread. So part of it is a national inconsistency about what we think we're trying to achieve, which parenthetically, I don't think is shared by the justices. I don't think they get caught up in what the nation wants from them. But they are getting a huge amount of attention. I worry what this term is going to bring in terms of public reaction to some of the court's decisions, whichever way they go. I think it's going to play into our divisions as a country. And the court is just in an impossible position. I think all they can do is try to act and react like justices and hold themselves to a high standard of conduct and writing and action, and be the best they can be in the face of this maelstrom in which they find themselves.
So to try and add just a couple things. First, on the Biden commission, the cynics, and in this case, I think the cynics were right, believe that he really appointed it just to kick the can down the road, because he personally is not in favor of any of the major reforms being talked about, but he had a big base within his party that was interested in those things. And he's been through enough commissions in his life to know that A, a lot of time passes, and B, that temperature cools a little bit. If I could bring about any of the changes under consideration, I agree with what Becky said. I think I didn't used to feel this way, but going to 18-year terms on the Supreme Court, which would mean that every presidential term would involve 2 appointments to the Supreme Court, that would potentially lower the temperature on the appointment process, and that would be a good thing. But the chances of that happening are, less than nil. It's just not possible given the political dynamic right now. So Biden got what he wanted, I think, which was some distance and cooling off. The Supreme Court as a political entity, it's kind of ebbed and flowed in how prominent the political nature of the Supreme Court has been. It's worth noting in this context that I believe Justice O'Connor was unanimously confirmed by the Senate, and Justice Ginsburg had a couple of votes against her. And that seems incredibly quaint and old-fashioned today, and it'll be a long time probably before that kind of climate exists again. But when the Supreme Court is deciding statutory cases, administrative law cases, they really are a lot like any other good court. They have their approach to construction of statutes and whatnot, but they're judging. But on these big picture constitutional issues, they're not really judges in any traditional sense. Judging doesn't tell you whether to recognize a new right that is bubbling up in society, unless you take the view of someone like Justice Scalia, that the Constitution means only what it meant in 1787, 1789. Otherwise, it is by definition, deciding constitutional cases a fairly political enterprise. And the bad thing about today is that everything is under such scrutiny. And in the, with the social media climate and all the other things, it's a hard time to be any kind of Supreme Court justice, whether you're a more, not partisan, but whether you have whether you're on the left or the right clearly, or whether you're someone more inclined to be more in the middle. It's just a tough time.
Thank you. So we've already talked about legitimacy a little bit, but I want to dig into that in a little more detail and get your thoughts on how you see current Supreme Court cases, potential reforms or failed reforms as potentially impacting Supreme Court legitimacy. And Becky, you talked a little bit about this in your last answer, but is there anything the court itself can or should be doing about the issue of legitimacy and popular support? I noticed we also have a question in the chat of, is the media to blame for this crisis of legitimacy? Is that where this is coming from? So I think we could throw that in there as well if folks want to jump in on media and legitimacy as well. But Becky, since you already addressed this a little bit before, do you want to jump in on this first?
Well, I'll throw a curveball a little bit, Sarah, by saying that one of the things that I think the federal judiciary, and to some extent, therefore, the Supreme Court needs to do, is grapple with the question of judicial misconduct. Do a much better job of figuring out a way to create a system that is transparent, that protects the people who need to be protected. And I think that courts in general and the Supreme Court as the standard bearer could regain some legitimacy by grappling seriously with that issue.
I want to absolutely support that and amplify it a little bit. I mean, we saw just recently the Wall Street Journal's just like shocking reporting on sort of judicial failure to reckon with their own, investment, self-interest and refusal to recuse. So there's that piece of it. I've been reporting for years on sexual harassment in the federal judiciary, in chambers, the things that have not, I think, necessarily been redressed in ways that have been open and transparent. The way Becky's pointing to. And then I would just say, in that bucket, I would say, at least again at the Supreme Court level, a Supreme Court that used to take 130, 140, 150 cases a year, and that had 54 merits cases. I mean, the lowest number, I think, in a century. And put aside questions of whatever the shadow docket. I know Justice Alito doesn't want us to call that, but that increasing numbers of cases are being decided in late night, unsigned, one paragraph orders. And so I think that a thing that the court could do tomorrow to remediate so much, and this was, by the way, part of the Biden Commission's mandate, was to look at ethics issues and look at some of these questions of who is policing the judiciary. And we didn't pay quite enough attention to that part of the reporting, but I think that a judiciary that rises and falls on public confidence, and I think people forget this, that that the courts don't have an army, they don't have a treasury, all they have is the public sense that they are legitimate. And I think that there are things the courts could do tomorrow to really, really bolster public confidence that they're not partisan actors, that they're not self-dealing, that they're not harassing their clerks in chambers and then making the claims go away, that they are not deciding things in unsigned opinions at midnight and then sailing off to give speeches. I mean, there are really an immense number of things that judges can do. And I think that if we're really talking about being at a moment where like the public is at a tipping point in terms of confidence, none of those things are hard. Those are not big lifts for a judicial branch.
And Sarah, to try and answer the question, that was posed in the chat, is the media to blame? No offense to Justice Alito, but no, the media is not to blame. I mean, the media has its own limitations as an entity and having to tell stories in a certain kind of way. But the media is such a diverse group of people. If you're talking about Dahlia or Adam Liptak or Nina Totenberg, how they covered the Supreme Court, you're getting a full, rich, nuanced portrait of what's going on. And and the questioner said, are they to blame for always referring to someone as liberal or conservative? And that is somewhat unfortunate terminology. But the fact of the matter is that most Supreme Court justices on most cases of a constitutional level, it's entirely predictable how they're going to come out, because they've staked out a judicial philosophy. It's different than a purely political philosophy, but they have shown over a number of cases where they stand on a general approach to things, and most justices will surprise you from time to time. But it is as I said before, the Constitution is an inherently political set of interpretations. So I think we're all to blame, not the media.
Yeah, I don't lay it at the feet of the media either. I regret the fact that there are so few reporters who are truly, again, to harp on the sort of knowledge and understanding note, who really understand the courts. And so when they report on them, it tends to be kind of glib and partisan. But I don't blame the media for the public perceptions of the courts. I mean, again, as Dahlia said, there are things that courts can do. They can do a better job of announcing their opinions so that they're easier to understand, so they're front loaded and they have pieces that jump out that the media can pick up. They can do seminars for the media to help the media understand their particular process. There are things the courts can do, and a lot of courts, most of them state, not federal, are doing those things actually in an effort to try to get the word out. So I don't think we can point fingers except perhaps at ourselves.
Thank you. Dahlia, there's a follow-up question for you in the Q&A, which was, what are some of the specifics of those things you think the court could do that would be quick and easy to bolster legitimacy? And why do you think the court is not doing those things? If we can do a little mind reading, I know that's tough, but.
I mean, I would start with the ethics rules and again, go back to that Wall Street Journal report. I mean, it's unconscionable. It is unconscionable that judges who have a financial stake in outcomes don't recuse 100% of the time. And, I clerked on the Ninth Circuit. I did a search every time, my judges' investments came up, we recused. I'm sure Becky would say the same. This is not difficult. And if you are not immediately looking at, and maybe this is a good, again, frame for it, we forget that the ethics rules that control judicial behavior don't go to, do you actually have a conflict of interest? It goes to, is there an appearance of bias or lack of objectivity? The standard is an objective standard. It is, would the average litigant walking into your court think that you are unbiased? And what that means is you conform your conduct as a judge to the appearance of neutrality. And that doesn't mean that you shout at people that you're neutral, with all due respect to Justice Alito. It means that you do everything you possibly can to perform neutrality. And whether that's, abiding by the ethics rules, whether it's abiding by disclosure and financial rules, whether it is abiding by rules of, if you've worked on a case in a previous life, or if you've got a family member working on a case now, you recuse. I mean, this stuff goes, it seems to me uncomplicated. But first and foremost, I would say the fact that those rules don't apply to the Supreme Court justices, that they're advisory they apply to all federal judges, whether or not they're enforced is a separate question, but they don't apply to the Supreme Court justices. And so I think that there is a need to sort of elevate the ethics rules, not just to the letter of the, can I defend my conduct, to the sort of exacting scrutiny of whether or not I am biased, and actually recognize that what the rules demand is that people feel that you are fair. And that means not giving partisan speeches. It means not commenting on cases while they are pending. And every one of those, I feel like, is now sort of subject to debate. And so I would just say it is not, I don't mean to minimize it, but these are not hard things to do. It requires making decisions as a jurist that appearance of neutrality and lack of bias comes before performing your politics or performing your, cleverness. And I just don't think that's difficult, but I think that it more and more has been encroached upon by a culture of, judicial celebrity, and I've got a book to hawk, and I've got, I'm mad, so I'm going to give a speech. So it requires a level of humility that is really, really not in evidence, I think, particularly at the Supreme Court right now.
Thanks, guys. So I want to shift our attention to state courts for a bit to make sure we get to have a full discussion of that as well. And we will have some time at the end for any extra Q&A that folks have from the audience. But David, I want to start with you here thinking about state courts. So at the state level, there is a much wider array of institutional arrangements for the judiciary than at the federal level, where it's laid out in the Constitution, and there you are. And there are also a variety of different reform efforts happening around the nation that deal with a different set of judicial problems and that are easier to accomplish because they don't require getting through Congress and they don't require a constitutional amendment at the federal level. So I'm hoping you can just kind of lay out for us the current landscape of what different variations we see in the states in the judiciary and what some of those major reform efforts are.
Sure, I think we'll probably talk a little more broadly than just courts, rather the legal system at the state level. And as I'm sure most of the folks watching this know, the states are really where the vast majority of cases are decided and where people go to get their rights defended or where legal issues are resolved in one way or another. There's something like 1 million federal cases filed a year, and there's something like 30 million cases filed a year in all the state and local courts around the country. And the number of judges tracks that. So, the legal system is really a state legal system, despite the attention that federal matters get. We at ISLES, which Becky founded, we just in September released a study called U.S. Justice Needs, which looked into a nationwide survey, first of its kind, to look at the kinds of legal problems that people face, how they resolve those problems, how they feel about the resolution of those problems. And it revealed, and this has been revealed in other ways by other organizations as well, that people from all income groups, all demographic groups, are impacted in very significant ways by civil legal problems. And very often they don't have access to the help that they need, or they don't feel that they were given a fair hearing or got a fair shake along the way. And that's the fundamental crisis of legitimacy that courts and regulators and legislatures need to deal with. One of the real core problems is people not having access to legal services to deal with the things that affect their lives, like divorce, potentially losing your home or apartment through eviction, debt collection, life-changing things like that. And basically, for more people to have more legal help, there's really only a couple ways for that to happen. One is for lawyers in private practice to do more pro bono work. And that's an important topic in and of itself. Legal profession has a very admirable history of pro bono work, but the needs are enormous. Second, there's pretty clearly inadequate funding of legal services organizations that provide assistance to low-income people, and it would be better if we funded that more. And the third way is through regulatory reform that allows legal services to be distributed to people in different ways. And Becky will, I think, talk about that in a couple of minutes. The good news is that there's a lot of experimentation all around the country in many different states. Part of this was forced on everyone by the pandemic, of course. Just what we're doing, a Zoom conversation, is now the way lots and lots of courts now operate, at least in part, and they certainly did during the height of the pandemic. And there's some real benefits to selective, intelligent use of technology like this in expanding access to justice. So, those are just a couple of the quick things I want to say about the beginnings of this conversation. And maybe I'll, turn it over to Becky and Dahlia, and we can talk some more.
Yeah, Becky, if you want to speak a little bit about regulatory reform and this idea of a broader set of people providing legal services, I think that would be great to bring in now.
Okay, so the concept is that historically only lawyers have been allowed to offer legal services. And we have a checkered history around the country of going after people for the unauthorized practice of law, anything from people who are offering services to somebody who wants to get something, a deed drafted, or they want a will or help with a divorce or a water right in Colorado. And the justification for protecting the right to offer legal services and limiting it only to lawyers is that lawyers are the ones who understand the ramifications, who can really help the clients. They're the ones who can protect the client's rights along the way, which in a perfect world is probably right. But we live in something far from a perfect world. And the truth of the matter is that millions of people go to court without the benefit of a lawyer. The numbers are staggering. Something like 70% in domestic relations cases of the litigants are self-represented. So what we have now started to wrestle with is, okay, how can we provide services? As David said, how can we distribute legal services to people in a way that makes them much more accessible, much less costly, and at the same time, those services would be grounded in knowledge and understanding of the law and would be regulated in some sense, a certification program or something. So the answer to those questions ranges all the way from what Washington State has called a limited license legal technician, a triple LT, which is somebody who is certified to offer legal services in a narrow slot of the law, but he or she can go to court with their individual clients, and it really gives people access to someone who understands the system in a way that they had not had before. And then the options range all the way over to what can Legalzoom do and not do? And how do we try to wrap our arms around what's appropriate there? Because clearly, if somebody wants to know something or do something, I mean, if you want to identify a plant, right, you download an app to figure out what the name of that plant is. If you want a legal service, people are inclined to download an app and try to figure out whether that legal service can be provided to them through the app. So there are a couple of states in particular, and more broadly, a climate which is very fertile for innovation. The state of Utah has created a pilot project, which they call a sandbox, where various options are being granted the imprimatur of the Supreme Court. They're going to be evaluated and tracked to see if, in fact, they are offering services to consumers that are useful to the consumers and that protect their rights, and if those services would not otherwise be available for those people. The state of Arizona has gone a step farther, and they are actually institutionalizing some of these changes, including allowing non-lawyer ownership of law firms, which is a really radical idea. Lawyers have always held that one very close and dear as well for a variety of reasons that we don't need to get into at the moment. But that then opens this field to innovative startup companies or to a different construction of a law firm that can include different layers of services or different kinds of professionals. The easiest way to think about this, and it's something of a sword and a shield, I realize, is the medical profession, which years ago moved to tiered services. So a physician's assistant or a nurse practitioner or you don't get to the surgeon until you really need the surgeon, and his or her services are very protected for certain kinds of cases, in part because of the cost. So I'm very encouraged about this movement in the law, and I think that it will have the possibility of transforming access to legal services. And I want to say as well that ILS has been at the forefront of this, as ILS has been at the forefront of so many changes. And there's some really wonderful leaders around the country who are championing this. And the Conference of Chief Justices is looking at it with interest and has approved the states that are experimenting in hopes that the data will emerge, which will then encourage additional states to move forward. So I view this as a really positive development in the landscape of legitimacy and access to justice.
And Dahlia or David, do either of you want to jump in on that as well?
I would say one quick thing, which is I absolutely agree that the states as laboratories for experimentation is really, I think, an object lesson in all the ways that we can think about the average American sense of the legitimacy of the judiciary is predicated on their last experience with the judiciary. And if they had a bad experience in traffic court or divorce court or in a domestic abuse, if they couldn't get access to language services, if they couldn't get access to counsel, that determines everything. And I think it's really what Becky's saying is so profoundly true, which is you build at that level so that people, have a day-to-day experience of a court in which they have confidence. And it is absolutely true, by the way, that domestic violence, having moved to Zoom in the COVID era has actually really bolstered a lot of victims' confidence in a system that otherwise would have had them showing up in a courtroom in a way that made them feel unsafe. The one thing I will add, and we'll see if David and Becky disagree with me on this, but Justice O'Connor, when she stepped down, devoted immense energy to trying to depoliticize judicial elections. And we haven't talked about it yet, but I do think that, when I sort of play in my headphones, Justice O'Connor in one ear and Justice Ginsburg in the other, it's the deep damage that judicial elections, I think, have done in terms of public. You just can't see 100 ads for a state Supreme Court justice that are completely cloaked in political claims and continue to have confidence in the judicial branch. And in the other ear, I think, is Justice Ginsburg saying, collegiality, civility, the way we talk to each other, the way we write, meeting each other with respect. And I think, I worry at the state level that both of those impulses are worrying to me, both in terms of how incredibly partisan and polemical and sort of compressed and shorthanded political discourse around what judges do. It really goes back to where Becky started. If people don't understand that these Punch and Judy commercials about elected judges do not actually reflect on what judges do all day, then I just worry that we're in a spiral that is really dangerous. So that's sort of, I put that out there and I'm happy to be corrected.
No, I think you're going to get really unanimous agreement on that point, Dahlia. Fortunately, Colorado is not this kind of state, but I used to live in a state, Illinois, that elected judges in essentially a partisan way. And there's multiple problems there. One, if judges have to raise money to run for office, who are they going to raise it from? Who's going to give money to a judge for a political campaign? Basically only lawyers, and that creates real and apparent conflicts of interest. Even worse, particularly at the state Supreme Court level, it forced justices to raise money either from the plaintiff's bar or the defense bar. And there were massive amounts of money spent on single seats on the Illinois Supreme Court, where most of the investment was from the personal injury lawyers on either the plaintiff or defense side. How much confidence is the average citizen going to have in a ruling by a court that they've seen out there, joining sides politically with either side in something like that? So, personally, I know, Becky can talk about this because she worked with Justice O'Connor in this, but the only kind of judicial election that to me makes any sense, if that, is a retention election after a nonpartisan appointment process. Becky,
I'd love to hear more from you about your experience with Justice O'Connor on these issues of judicial selection.
And I don't want to ramble here because this is a topic on which I could, so I will try to be succinct. It was indeed one of Justice O'Connor's most cherished ideals was an independent judiciary. And she believed that electing judges flies directly in the face of an independent judiciary. And that's just sort of the beginning and end of the sentence. She also, however, given her pragmatic sort of realism, recognized that there had to be some accountability, that the federal judiciary lacks accountability. We've been talking about that a little bit. And over the course of history, the citizenry of our states have made it very clear that they are not willing to accept an unaccountable judiciary. That's just sort of ingrained. So how do you balance that? And the best way to balance it, in my view, and in Justice O'Connor's view, is this modified Missouri plan to which David refers, which is initial appointment by a sitting governor, usually, although there are some variations even on that theme, after a nominating commission tees up the names, and the individual then serves until some point at which he or she goes before the electorate for a retention election. And in Colorado, Utah, Arizona, New Mexico, a number of states, there's a very robust judicial performance evaluation system, which provides information to the voters about the particular judge who is appearing on the ballot, and thus the accountability, thus the balance, without sucking the judge or justice into the political melee that both Dahlia and David have spoken to. I want to interject here just because this is about Justice O'Connor and this is about this subject. We had an O'Connor advisory group that worked with Isles for a number of years, and Justice O'Connor was the honorary head of that group. At the last meeting we held of that group, which was in Phoenix, she was in a wheelchair and Ruth McGregor was wheeling her out of the conference room. And she looked up at me and she said, "Becky, come here." And I leaned over and she said to me, "I'm fading away, but you have to keep up this work. There is nothing more important to this country than the independence of the judiciary." I mean, it still gives me goosebumps, but this was one of her most heartfelt issues and something that she believed was core to all the questions that we've been talking about in terms of legitimacy. So all of us and everybody on this call, we have that charge. We have to stay true to the notion that we have to defend and support an independent judiciary, however we can do it.
Well, on that note, I think that leads perfectly into a closing question. And before I ask it, I'll just say last call for anyone in the audience to get in any final questions in the Q&A or in the chat. But building on what Becky just said, for someone who is watching this webinar tonight, where might be the biggest opportunities for change and how can people get involved in that?
That's a tough one, given the nature of the issues that we're talking about. I mean, you know, the decision to respect judicial independence is itself a political decision. So people can have impact by demanding, in whatever form their political advocacy takes, that politicians, whether they agree with them most of the time or not, treat the judiciary as the cherished prize that it needs to be in a society of laws like ours. You know, everyone who attacks judges for doing their job, attacks the judiciary, they're hammering away at a important ice sculpture, you know, in a sense. And if you hit the wrong spot, we've seen it can all begin to crumble. So we need to demand of our political officials to leave the judiciary independent.
And I would maybe just add, I've said this in 7 iterations, but I'll say it again, that the judiciary also has a responsibility to behave independently and to forswear, you know, the easy, quotable, punchy sort of AM radio discourse. And I think it must be very frustrating to be a jurist and not be able to talk in the language of the juror of the day, you know, the sort of lingua franca of how the rest of us talk. I just don't think it's helping. And I think we haven't talked, but I will put it down as a marker about facts, because, you know, the reason I went to law school, and I suspect the reason that you all went to law school, is because facts matter and truth matters, and those things are immutable. And it's very frustrating, I think, to live in a world where fact has been conflated into opinion, which has been conflated into politics. And so I do tell people who are losing confidence in both the judicial project and the legal project that fighting for fact and facticity and truth, and that not everything is a function of what you want to believe or, you know, find your own answer, I think is a part of this conversation. And that we have to be really vigilant and protective of science, of public health, of data, of all the things that are sort of now being thrown in the air. And I think the judiciary has a role in that, in not departing from truth and fact. I also think the public has a role in that. And I think that, you know, if we sort of end where we began, which is confidence in the judiciary, I think David said this, it is a personal choice, and it is related to a personal choice to believe in fact and truth and science and reality. And those are things every single person not only has a stake in, but I think has the ability to fight for.
So my parting comment would be get involved, all the way from, if you get a juror summons, show up and be proud to be there. If you can serve on a judicial nominating commission or a judicial performance commission, or if you're an attorney, become involved in mock trial, moot court, teaching about the system, giving talks about this, interesting talks, not lectures, but interesting talks about the system. But do something that is a step toward making the system what you want it to be and helping others to understand its importance. If all of us do something, the system is sure to be better tomorrow and the next day and the next day. So my plea to everybody is don't just sit on the sidelines and snipe, participate, be part of whatever solution you think serves our democracy and our system. And thank you. Thank you to you, Dahlia, and to you, David. This has been great fun. And thank you for moderating us and keeping us on track, Sarah. we appreciate it.
And we do have one question in the chat that I'll just mention if anyone has thoughts about how we can influence judicial independence in our state. I think this person might be from North Carolina, which I know is not the specific expertise necessarily in this Zoom room, but it sounds like a couple of these options that Becky has mentioned are serving on commissions, getting involved in education efforts. Is there anything else folks want to throw out there about involvement at the state level that people might think about?
I will take a quick cut, which is I think that state judicial races are very, very politicized now. I think that we have, for the first time, David probably knows these numbers better than I, Supreme Court justices, state Supreme Court justices punching each other and, getting into fisticuffs. And so I think that having an electorate that's interested in judicial races, that is invested in them, that understands that it's not just, a down ballot matter. And by the way, this is true of school boards, and it is true of, your state attorney general. But I think helping people have a deeper understanding of what the stakes are in judicial races. And then I also just think we've seen really a lot of state Supreme Courts that are being fiddled with in all sorts of ways in terms of stripping jurisdiction and stripping state Supreme Courts of power, and just to be really mindful of the ways in which, whether they're functioning or not, state courts are becoming political footballs in some of the states, and really, really be vigilant and mindful about whether that's happening in your state. And I will leave it to David and Becky to talk about whether there are actual moves, but I think, it's a good question because I think it really surfaces how politicized state courts have become in some states.
Yeah, in most states that I'm aware of, there is one or more organizations, not-for-profit groups that work in this general space of trying to preserve or create, in some cases, the independence of judiciary. So with a little Google search, I'm not familiar with the status of things in North Carolina, but you can find those groups and they'll have programming and opportunities to get involved where you can be with like-minded people and make a contribution.
All right, well, thank you so much to our panelists. This was such an interesting discussion this evening, and I really appreciate us all taking the time to do this. And thank you to Tattered Cover and to the Sisters-in-Law Play for making this all happen. And Alan, I think I'll turn things back to you.
Thank you all very much. Sarah for moderating, Justice Corliss, David, Dahlia, thank you so much for offering a really fascinating conversation about the future of the judiciary, how we can all be involved in it and its effect on our community at large. So thank you all so much for taking the time this evening. And thank you all for being here with us as well. We appreciate you joining us. Let me quickly turn over to Diane to talk about the play, which has some very exciting news. Diane.
Well, the play is completely sold out for the remainder of the run, but we do have cancellations and some potential openings with some house seats we haven't released yet. So if any of you are out there and still want to come see the play, email theateror@mindspring.com. We do have a waiting list for each show, and a number of people will be able to get in. So thank you very much for that.
Diane, thank you. No, it's a wonderful play. It's gotten great reviews. It's a great topic, very well produced, and I implore you all to go see it. It's a great presentation. You will be receiving an email in the next couple of days with a recording of this presentation, along with recordings of the other 4 installments of this series. You can also see them on youtube.com/tatteredcover, or you can visit the webinar series page at tatteredcover.com/sisters-law. Again, that will be in the email as well, but we are very grateful for you all being here. We've enjoyed having all of our excellent panelists over these last, it's been about 6 weeks. We appreciate everyone's patience and understanding. This has been a fantastic series. Again, thank you so much for being here. Have a great night. We'll hope to see you again soon. Thank you.